So as I've said, that we'll be moving on talking about the constitutional, which is crucial. So I'll be reminding you about some of the things that I've said so that you know what I've said. And then when we move on a good note. Firstly, you must never forget about the judicial system, as I have said, that the hierarchy of the Constitution. They do ask in the examination, tell us the hierarchy of the Constitution. So you must know that the highest court will be Constitutional Court, the Supreme Court, the High Court, and the Magistrate Court. But remember, they will be you will be required to describe or to describe their jurisdiction. Of course, the magistrate court, as I have said, magistrate court cannot validate the conducts of the president, and number two, it cannot validate the legislation. So this is according to section 1110 of the Magistrate Act. Remember, 1110 of the Magistrate Act. Don't forget. You can see this is section 1110 of the Magistrate Act. It made it clear that a court shall not be competent to pronounce on the validity of any law or conduct of the president if it's in any proceeding before the court is allegedly that any law or conduct of the president is invalid on the ground of its inconsistency. And then they said when they move. Now, you know, the magistrate court cannot validate those conducts. It's their jurisdiction. Now, when we come back, we have a high court. Remember, high court has an inherent jurisdiction according to the section of the high court. Therefore, the high court can validate the action of the president, and the high court can invalidate the statute. However, they will wait for the confirmation from the constitutional court. The constitutional court must confirm, and then they must confirm the validity of the statute and the validity of the conduct of the president. Now, you see. Now, Supreme Court of Appeal used to be the High Court. The Superior Court in the olden days. But now they only hear the appeal. So Supreme Court of Appeal will never be the court of first instance because this court will only hear the appeal from High Court. The appeal from High Court. You have done it when you are doing a civil procedure. Right. And then there's those courts that are established by the high courts. You know, I've already said about those ones. Those ones we talk about the labor court that is in the labor court and labor appeal court is found in Braamfontein, I believe so. It's in Braamfontein, the labor court and labor appeal court. We have the labor claim court, which is in Middle Randburg, the competition appeal, the electoral courts, and the tax courts in Bloemfontein. So in Pretoria. Now, all these courts are established by the high courts. So it's part of the high courts. It's been established so that they can specialize on these particular matters. Don't forget that. Now, I said that on the constitutional court, I said that there are matters that they will only be heard by the constitutional court. So the constitutional court has an exclusive jurisdiction with such a matter, and then those matters have been listed in section 167, subsection 4 of the Constitution. Therefore, these are the matters that they have exclusive jurisdiction. Now, of course, as I have said, that the judicial independence and impartial is very crucial. So whenever you get into the examination, you'll be asked about the judicial independence and impartial. So how the judicial is independent and how the impartiality of the judges. And then, firstly, I'm gonna remind you about what they check when they nominate the judge, or when the on the interview of the judge. What are the characteristics of the judge, by the way? Okay, firstly, we look at the characteristic of the judge. Remember about this document about the Judicial Service Commission, which I sent to you, and I said that it has characteristic of the judges. So it's very crucial that you start by checking the characteristic from this document. And the number one will look at the independency. They say that the judges should make their own decisions independently and be possessed of courage, fairness, and good judgment. So those are the characteristics of the judge. Judicial independence means that the judge is required to make up his or her own mind on an issue independently of pressure or coercion from some other person or body, and independently of loyalty or affiliation to some other person or body. Then they say that the judge must have the courage and the integrity to be able to resist the pressure, which may be external, such as political, commercial, or personal, or internal, such as a desire for popularity, and even the pressure of a direct threat. A judge should deliver a judgment which he or she believes is required by the law and evidence before them and should not be diverted from this course by any such external or internal pressure. Um, mm, yeah, there are many, Um, they talk about even the membership, political, um, of the. They say that this does not mean that the candidate has to be free from for personal conviction, political, but the candidate must have a capacity to put his or her own conviction at a sufficient distance. Blah blah blah. Blah. So those the one that I want you to know, even the one that you can use in the examination, is number 32, 31, and 30. Those are the ones that are good characteristic of the judges. Now, we have seen the characteristic of the judges, what the judges are required to do. Now, let's move back to our independence. Now, before we move on, we have to check who are the judges. I told you that magistrate court we have magistrate, right? Judges are from the superior courts. Now, number one, we have a chief justice. The South African chief justice is Mandisa Maya Mandisa. She's the first woman to be chief justice. And then we have the president of the Supreme Court of Appeal. Mandisa was the president of Supreme Court of Appeal. Now she's the chief of the justice. Remember, we have the judges of the president of the High Court, and we have the judges of the High Court, and then we have many. So the thing that I want to see, this is the structure for the JSC, by the way, but I want to show you the one of the judges. Remember, according to the Security of Tenant and Financial Security as an independency, I said that a judge are only appointed for a fixed term, so that they cannot be like those who go out there to toy toy, right? And then I said that the constitutional judge should be there in a non-renewable term of 12 years. So my mind is I have signed a 12-year fixed, it's fixed, non-renewable, right? And then she will be there until she has served the 12 years or when she have reached the age of 70, whichever will come first. So after age of 70, cut, you go. So that is the constitutional court. That is the constitutional court. However, the terms of the office can be extended, right, on the constitutional court. So it doesn't mean that it's a 12 years, then 12 years you are done. They can extend, as they've said. Now, remember, this is this is the constitutional court judges who, and by the way, they are based on section 4 of the Judges Remuneration and Condition of Employment Act, which extend their term to 15 years active service. Now, this service performed as a judge on any other court. Now, a constitutional court must nevertheless retire when he reaches the age of 75. The practical effect of this provision is that judge of the constitutional court who has been in active service on another court for more than 3 years will usually save 12 years term on the Constitutional Court, unless they reach the age of 75 before the end of that term. A judge who has not served on another court before being appointed to the Constitutional Court will usually serve 15-year term, provided he does not reach retirement age before the end of his term. Now, before I moved on, um, I will look at this independency. I'll come back, but I want to remind you about other things that I have studied with. Sorry, the thing that I wanted to discuss with you was impartiality, where we'll look at the case of the Van Rooyen. Remember, I've said about the case of Van Rooyen, about the impartiality. What happens during the case of Van Rooyen? Now, they say that the test for impartiality was formulated in the case of South African rugby, and they affirmed in Van Rooyen is whether a reasonable, objective, and informed person would, on the correct facts, reasonable apprehend that the judge will not bring an impartial mind to bear on the adjudication of the case. The test is objective and must be properly contextualized, taking into account a balanced view of all the material information. The informed person posited in the test is thoughtful, aware, and sensitive to South African complex social reality, rather than clinical paranoid or hypercritical of its past and present. Now, those are the tests for impartiality. If you get into the examination, they're asking you about the test for impartiality. You know about those tests of impartiality is there. Those are the things that I wanted to show you so that you know the case of the South Afro, and then it was motivated by the case of Van Rooyen. So that is the case. Remember, impartial can be about the bias, it can be about the recusal of the judge. It's the same thing. The judge can be recused if there is some of these objective tests. Don't forget that when you get into the examination, it's the opportunity to get everything in the exam. And then another thing is the electoral system that is used. And then I said that the electoral system that is used is the closed list proportional representation system, which is more effective of the voting population as a whole. Let me do this, by the way, so that you can see. Yeah. The closed list proportional representation system is more reflective of the voting population as a whole because the seats are assigned in proportion to the number of votes received. The minority parties are also represented in the parliament. This in turn leads to a more inclusive legislature as minority groups and previously disadvantaged groups are given representation, even if it is a smaller number of seats. So this is in line with the aims of our constitution, which value diversity and inclusiveness. And then they said that the problem often associated with the plurality system, which involve the manipulation. So when we talk about the system, don't forget to read about it. This question would usually come about the electoral system. The electoral system in South Africa is this one. They've been written, even the disadvantages. So you must take a note of it so that when this particular question comes to the examination, boom, you are winning. Then you know that everything is well, I'm winning on this one. Then you win. No, so I think that it will be a good one for this one. I hope that you will not forget this one, because you must not forget, since it is good. Now let's move on. Now, don't forget about the basic principle of constitutional law. Mostly it comes to the examination, and I'm still repeating them. Number one, we have a constitutional supremacy, where we talk about the supremacy of the Constitution. Yesterday, I told you about Section 2 of the constitutional supremacy, so I know that you have not forgotten that. Another principle is the separation of powers. I know that I've told you about the separation of powers. is there, this document that I've sent to you, and then I hope that you are reading it. Then we have the rule of law. As I have said, that the rule of law is the one that it comes in the examination most of the time. So it's very crucial that you follow how it has been explained, so that it becomes easier for you in the examination. The other principle of constitution. Number D, we have a democracy. Democracy is another principle of a constitution. So you must take note of this one and what is a democracy, the models of democracy, the different types of democracy, so that when you get into the examination, it becomes easier. Remember about the models of democracy. I said that we have a direct democracy, which is based on Section 17 of the Constitution, which guarantees the right to petition, and Section 84, which have a referenda. We have a representatives, which is the citizen elected representatives who vote on political issues on behalf of citizens, like Section 1D, a voter's role, and then we have a Section 57, Section 17. Then we have a participatory democracy on the other side, and then don't forget. So number E, the last principle, is the transformative constitution. We know about the transformative constitution. It aims that they transform this country from deeply divided and equal to a undivided and equal society, which is founded on the values such as equality, dignity, and freedom, where all humans live together in harmony. That is a transformative constitutionalism. So this was the property law. We'll continue, guys, tomorrow when we go forward. I told you that you must come and tell me whenever you don't understand, so that we look at those chapters that you don't understand, so that you repeat those chapters so that you understand. Because you may find that maybe I'm repeating something that you now know. So you let me know.